Check 1, 2. You don't hear me talking on the thing right now. Check, check, check. Check 1, 2.
Testing 1, 2. Good afternoon. Thank you guys for coming to the General Government Subcommittee for Government Affairs. We're going to start off with a word of prayer from Representative Williams.
Thank you, Mr. Chairman. Let's bow our heads. Dear Lord, thank you again for another day. Please bless this world. Please heal this world. Please have mercy on the people of Ukraine. Please bless our law enforcement officers and our men and women in harm's way. Please help this world and help us to do the right things and make the right decisions. Give us the courage, the moderation, and the wisdom. In thy name we pray, amen.
As a clarification for those who haven't been through the Government Affairs Committee, the procedure here is for all bills to go through a subcommittee. The preference of the chair lady is for amendments to be reviewed and discussed in subcommittee, if at all possible. There is no votes on any bills within the subcommittee that's not indicative of a positive or negative, but it is eligible to be heard and voted on after one review in subcommittee, if not necessarily multiple if required. With that in mind, Representative Gaines has requested to go first, and we will hear SB 534. If you would clarify your LC number just to make sure the committee has the appropriate one.
Well, thank you, Mr. Chairman. Good to be back with you. It's been a year, but it's good to see you. And we do have a substitute to Senate Bill 534, and the LC number is LC 471798S. Is that what y'all have in here for?
Nope. Say that again.
LC 471798S.
No. Yeah.
Wrote all over. No, sir. And I can start explaining the changes while Molly make. Do y'all have LC 365119?
Yes.
Okay. So that's as passed by the Senate. But I.
Do you have a substitute?
Oh, she's already got yes.
Okay.
And she's passing out changes. And I'll point to where the changes are in the two bills. This is a measure by Chairman Kennedy. He was not able to be here. I'm sponsoring the House, and he asked me to present it this afternoon for him in his absence. And I'll quickly highlight the changes between the House and the Senate version and the substitute before you. And those changes were largely made as a request of the Secretary of State's office, and it starts on line 54 in the version that you have that passed the Senate. It's lines 54 is again where the changes are. It's the changes between A and B, and you have the two different versions. But again, this was some collaboration with the Secretary of State's office. But overall, I'll just highlight the goal and the objective of the measure, and then I'll be happy to take questions. There's also Megan Schmidt from the Philanthropy Roundtable that is online, and the Secretary of State's office, I believe, is here, the head of their philanthropies division. But what we're trying to do here is protect charities in our state, and to make sure that if there are additional rulemaking requirements imposed by an agency, that the General Assembly be notified of those changes and to have input. Because we have seen in states that there's been additional requirements put on charities. What we want to do is allow our charities to do the good work that they do in our communities every single day. In Georgia, there's over 5,700 incorporated charities that are actually based here in Georgia. And so what we want to do is continue to allow them to do the good work they do, especially after the instability of COVID-19. We do have a good environment here in Georgia for charities, and we want to protect that. And that's what we believe the Charity Protection Act does in Senate Bill 534. Again, what it really boils down to is it gives the General Assembly notification if there are rulemaking changes that specifically, and I'll read the language, that specifically require any new or expanded filing or reporting requirements, or that would limit the ability of charitable organizations to solicit or collect funds. And that's when the agency would be required to notify the General Assembly, as with other rules that we have in place. And how that plays out is that the Secretary of State's office, or wherever that rulemaking happened, would notify the House and the Senate. That rule would then be sent to a chair of a committee that it's related to. And then if there is objection by the General Assembly, it would come back before both bodies. If that vote is a 2/3 majority in both chambers, then the rule would be rejected if there is objection by the General Assembly. If it's a majority vote, but not 2/3, it would go to the governor for a signature or veto. And that's not a change in law. That's how it currently applies, but this just adds that charity component to it. And I'd be happy to answer any questions, or we can have Megan present as well.
Thank you, Chairman Gaines. Would you further clarify? I know you spoke to it, but because not all members currently, there's some more copies on the way. Would you tell me which specific lines
Sure.
are modifications from what the committee has before it, which is as the Senate passed and the new substitute you're proposing?
Sure. So on lines 54 on both versions, everything up to line 54 is the exact same. And then from lines 54 to 68 in the old version as passed by the Senate is replaced with lines 54 to 63 in this version.
Okay, so you're saying in the old version, 54 to 63 to 64 were replaced by 54 to 63 in the new version?
That's right. So
So
A and B.
A and B.
That's right.
Trying to, so it's not, is it, tell me the difference of these two subsections.
I
What
may
was
let the
changed?
Secretary of State's office
Would that be
discuss that a little
preferable?
bit, because
That's
that
completely
was
fine.
a request of theirs.
Okay, let's, before questions, let's go ahead. That way would the committee gets a clear understanding on those sections. I'm going to go ahead and read out while the Secretary of State comes in what is on the new section. Line 54, absent the showing of a compelling state interest, not impose any annual filing or reporting requirement in an organization regulated or specifically exempted from regulation under the Chapter 17, Title 43 of Georgia Charitable Solicitation Act of 1988, that are more burdensome that the requirements authorized by applicable law. Any such filing or reportable requirements shall be narrowly tailored to achieve such compelling state interest. The requirement of this subsection shall not apply to the state's direct spending program. B, email the notice provided for the paragraph 1 of this subsection to each chairperson of any standing committee in each house as shown as on the General Assembly website. All right, so that's basically the way to give notice, and
That's
it
right.
seems like it modifies it. Is the Secretary of, is there a representative from the Secretary of State here? If you'd come up and you can sit on the second chair if that's all right, just to give a note of why that change was made here.
Thank you, Mr. Chairman,
Comment.
and members of the committee. So as you noted that the Securities and Charities Division of the Office of the Secretary of State.
I'm sorry,
administers-
for the record, could you
Oh,
state your
I'm
name
sorry.
and title?
My name is Nula Zaharis. I'm the Director of the Charities and Securities Division for the Office of the Secretary of State. So as I stated, that we administer the regulatory provisions of the Georgia Charitable Solicitations Act of 1988. So we have fundraising oversight. We have oversight of the fundraising activities in Georgia, and we monitor the charities industry for potential fraud. So our division is supportive of legislation that has a positive impact on both Georgia donors and the charitable organizations. So this bill that was presented addresses limiting rules which place administrative burdens on charitable organizations. Our division's approach to rulemaking has been the exact opposite of what the original bill suggested. We don't oppose the current bill because it reflects our current philosophy on rulemaking. We have shown a commitment to charities by doing what we can to reduce the burdens, and we have done that through our rulemaking, the current rulemaking. So let me elaborate on how we've done that. Charitable organizations that solicit funds in Georgia must register with the Secretary of State unless they are exempt from a registration. There are 9 exemptions from registration. They're pretty broad, but if they meet one of those exemptions, they don't have to register. So the registration and ongoing requirements are addressed in the act and not the rules. So at this time, we do have over 5,500 Georgia-based charities, but we have over 12,000 charities that are registered with Georgia. To streamline the registration and renewal process for charitable organizations, the division made 2 rule changes several years ago. The first one was in 2016. We adopted Rule 599-4-.07 that would allow charitable organizations that did not file a Form 990 with the IRS to submit a Form C-200 in order to register or renew as a charity in Georgia. Prior to the adoption of this rule, the Charitable Solicitations Act of Georgia solely authorized the division or the Secretary of State to accept a 990. However, the IRS allows smaller charities with $50,000 or less in gross receipts to file an e-postcard. So this is just an electronic filing attesting that they qualify for that. There's no paper filing. Under our current act, we could not accept that filing, which meant that charities that filed an e-postcard with the IRS could not meet the registration requirements in Georgia. If they wanted to register in Georgia, they had to go back and file a 990 with the IRS, which a 990, if those of you who haven't filed one or seen it, it looks like, is this. It's very burdensome.
No,
Not just
normally
with-
takes a
yeah.
professional.
It takes
to
a
compile it
professional,
for you.
absolutely. I work with in a previous job, I worked with the foundation, and it takes a professional, and it costs a lot when you hire that professional to do this right. So what we did instead, we came up with the Form C-200. The Form C-200 is 3 pages long. It is the section part 1 of the Form 990, which is the information about revenue, expenses, changes in net assets, or fund balances. And since sound financial management is an important factor in determining Georgians' trust and confidence in charities, we felt that that was the most important information to get. So our Form 200 is very simple and just 3 pages. And instead of the, thing, and you can do it online as well. This rule was specifically designed, or this rule change was designed as a rule to help charities, but in particular, the very small charitable organizations, many of whom are Georgia-based, small businesses, to meet the filing requirements and get them up and running. And I took a look before we passed this, we didn't have that many e-postcard filers. We probably had about 10 a year, but 10 is one too many. So we decided to help them with that. The second time we changed the rule was in 2017. We amended Rule 599-4.01 to allow charitable organizations to use the uniform registration statement when registering, and to eliminate the requirement that the Georgia registration statement be notarized by an official witness because the URS, the uniform form, does not require it. So the uniform registration statement is a consolidated form that was created to help nonprofits complete multiple charitable solicitation registrations in multiple states at the same time. So it takes all the different states' requirements and it puts them all into one form. And the point is to streamline the process and to help the charities. So we passed this rule to adopt the URS, and we also passed a rule to not require the Form 100, the C-100, to be notarized. We wanted to keep the process the same, so that was done. Again, through the current rulemaking, we ease the burdensome filing requirements, specifically, designed to make the process quicker and more efficient and streamline it in order to get registered. I think, Senator, you said something about allowing, the charitable organizations to, do their job and be protected. We agree with that. We'd like to partner, and we do partner with our charitable organizations in helping them to do. One of the key things that we do is to protect Georgia donors and businesses against fraud and other misconduct. In the current rule, there's 599-5, which is untrue and misleading statements prohibited. This allows Georgia to hold persons accountable for providing true, misleading statements and misrepresentations. So we work with the charities to do that. Donors are not the only persons that get scammed. We have found that charities get scammed too. We've had an incident of a charity being the victim of an imposter website. The charity, an imposter bad actor set up a website just like the charity site, hired individuals to work for him. Those people were calling donors in Florida and Georgia and South Carolina and Alabama. And the monies were all going to that person's individual PayPal account. So we worked with the charity. How it was discovered was a Georgia donor who attended several of our outreach events on how to protect yourself against fraud, asked the person who called a question about how the funds were being spent. The young lady who was working did not know. Instead of calling the bad actor number she was given, she did an internet search, found the legit charity, called the charity, and that's how the fraud was discovered. So we partnered with that charity to do that. But that is what we are committed to doing, is working with charitable organizations and with donors.
Thank you. I believe Representative Williamson had a question either for the author or for. You should be on.
Thank you, Mr. Chairman. That's intriguing testimony, but I had a couple of questions. I walked in a minute after the Representative Gaines began presenting the bill. Is this then a department bill? It is not. What was the motivation behind bringing this bill?
So the Philanthropy Roundtable, which we'll hear from Megan Smith, she's online. Maybe she could better outline that. But what we're trying to do is make sure that we are looking out for charitable organizations in the state. And so maybe Stephen or Mr. Chairman, excuse me, may be appropriate to hear from Megan to outline that a little bit better too.
Well, and then I had a couple of follow-up things maybe before she got on, just for you, Chairman Gaines. Does it do, in your opinion, does it do anything to lessen control over these bad actors? We just got an example of a bad actor just a minute ago.
I don't believe so.
Okay. And then the follow-up to that question is, who actually audits the bad actors? Is it the Secretary of State's role? Or?
Yes, sir, we do. So if we get a complaint, which we immediately follow up on, the first thing that we do actually is through the registration statement documents. We have a lot of the bad activity doesn't happen with legit charities that are registered. It happens with people who are trying to fly under the radar. A bad actor doesn't want to register because he doesn't want to get caught. So we had one, which we partner, and I'm sure you've all heard of it, is the Georgia Peach Kids case, where we received complaints from several citizens and law enforcement about a charity going out door to door soliciting, having children selling candy, basically. So we found out what their name was, saw they had a website, saw that they were saying that they were a charity. So we reached out and asked them, why aren't you registered? And they decided to register. Through those documentations, our attorneys and our examiners took a look, because they have good background on reading financial statements, that something may not be right here. So we decided to call the GBI and the AG's office and work, and tell them there's something maybe afoot here. So we worked together, our teams worked together. And after our investigation, there was an indictment of the charity and 13 other defendants. They are facing charges of racketeering, charity fraud, and 4 counts of human trafficking. And that was discovered because why? They filed the charity's registration statement, and we caught it.
Thinking just a short kind of yes or no, was the gentleman or the bad actor, the fraudulent charity you alluded to earlier, was that person indicted as well?
Yes, that was taken care of by the Federal Trade Commission. We have a federal partner, so we don't do things solo. It's our, philosophy of working together.
Were they prosecuted?
I think they're in the process of doing that, the Federal Trade Commission, right?
Thank you. Then, so then it's just back to the question of what the motivation of the bill is and why it's needed and all that. Again, I walked in late. You might have already covered that.
Yeah, and again, Megan, maybe even better. But I mean, one of the reason is because some states have imposed, frankly, some ridiculous requirements on, reporting and different things on charities that are taking time away from them doing their work of actually serving their communities. And so what we're trying to do is make sure that if there is any rulemaking, they would have to notify the General Assembly if it's a burdensome regulation that is outlined in the bill. And so they would have to give notification to the General Assembly. And so it wouldn't prohibit them from making that rule, but it would give the General Assembly a say in that rulemaking process.
And to restate the author's point, I think it's an important line to be drawn, and I think the Secretary of State is noting that as well, that we don't want to create, New York and California are notorious for very hands-on policies that create a financial administrative cost for these charities, and which most donors would prefer them going directly to the mission. However, those negative actors do also take away the dollars of good and purposeful charities, and we want to be able to make sure that the tools are there. This bill does nothing to prevent those tools from coming in place, but it does give the people's representatives the ability to ensure that it meets a valid threshold of burden for these charities. Would that be fair
That's
to say?
right.
All right, with that, we have one individual who would like to speak. I believe it's who Representative Chairman Gaines noted, Miss Megan Schmidt. If you're online, you're being recognized.
Thank you, Mr. Chairman, members of the committee. My name is Megan Schmidt, and I am the Director of Government Affairs at the Philanthropy Roundtable. Today, the Philanthropy Roundtable has around 600 active members consisting of private, community, and family foundations nationwide, including right here in Georgia. Our mission is to foster excellence in philanthropy and protect philanthropic freedom. Georgia is home to thousands of foundations that give billions to charitable causes each year. This bill allows Georgia charitable organizations to focus on their governance and grant making instead of being subjected to the uncertainty of additional filing and reporting requirements. This bill is simply adding a layer of transparency and calls for any proposed filing or reporting requirement must first go through the legislative process. The Attorney General would still have full investigative and prosecutorial authority to go after any bad actors. 7 states have enacted this legislation so far, including Iowa, Kansas, and Arkansas. And these states have made it hospitable for charities and created a predictable regulatory environment. And if you have any questions, I'm happy to answer them. I've got some examples of some other states where we've seen some of this overreach happening. But at the end of the day, we really just want to keep Georgia hospitable to charities.
Thank you for coming. Just a clarification, I think you noted it to a certain extent. Does the Philanthropy Roundtable exclusively represent donors or exclusively represent nonprofit philanthropies and charities, or is it both?
So it's donors, but our donors are community, private, and family foundations. That is who our donors are. So it's the nonprofits.
Gotcha. So donors who are also nonprofits. But what I was trying to get back an intent is your group has a mutual intent to ensure that those in which you're giving to have appropriate oversight, which of course the primary one is the local board of directors, but that have appropriate government oversight as well. You're not trying to limit oversight in general, just overly.
No.
Okay.
No.
Thank you. Is there any other member of the committee who would like to speak? 12, you're being recognized.
Thank you, Mr. Chair. I guess I'm kind of agreeing with my colleague. I'm trying to understand what prompted this now, and maybe you're the best person to speak to it. What generated the need for this legislation now? Thank you.
Sure. As I mentioned, we're seeing in other states, we are starting to see some of these state agency officials, primarily the Attorney General, but there have been cases with other agencies as well, where they're starting to, I would say, extend their authority. And so in our opinion, if this can go before the legislative process and make it more transparent for legislators, make it more transparent for these foundations, I think it helps everybody. An example would be, in Hawaii, the Attorney General's office subpoenaed all documents relating to the nonprofit's financial accounts just because it opposed the construction of the 30-meter telescope. And that's just one example. I've got more if you want, and I'm happy to go through those if you'd like me to, but I think we just want to keep these states, like I said, hospitable to charities. We want, we want Georgia to keep it friendly. We don't want charities to leave the state and go to other states that might be more friendly to some of these organizations.
Does a charity that operate, and I'm going to ask you, and you may not know this, but, and that's perfectly fine, but does a charity that operates in multiple states usually have to register in each state in which it operates in, or is it only where it's headquartered at? Be it,
Secretary of State's office might know this better than I do, but I do not believe they
So
have.
I'll hold and ask this, redirect that to the Secretary of State.
Yes, I'm a registration expert. Before I came to Secretary of State, I did a lot of registrations for different things. So absolutely, if each state has its own laws. With charities, there in some states, charities are overseen by the Secretary of State's offices. In our state, it's Georgia, which is an administrative, we go through administrative procedures. In other states, it's the Attorney General's office. So they have different, things like New York and California, they're under the AG's office. Yes, they do have different, they have to register, not based on, they have to register based on if they are soliciting in that state, reaching out to donors in that state.
So not necessarily if they were and probably practically if they're operating in that state, their mission, they're probably asking for donors in that state as well.
Yes, but we have exemptions in Georgia. So if you have collected 25,000 or less, from donations in overall donations, you don't have to register in Georgia. You're exempt.
I don't see any further questions. I do have one. It's not necessarily based on the bill specifically, but the bill's intent of towing that line. So my understanding is the Secretary of State's office is responsible for investigating public, and I think you all still have a portal you can look
Yes.
at or report possible instances of
Yes, we
charitable
do.
misconduct. What I know the case, do you have the numbers of reports made versus cases conducted in the last several years?
So I do, I had that number. I am sorry, she gave it to me. I think I'm going to say it's over 100 that we've gotten the past year. And honestly, we look into everything. We do. We look where we start off usually from, we use the registration as a basis to help us decide, is it here, is it that?
When you say look into, does that mean that an investigation is opened and
It is open. Yes, it is. Mhm.
and a determination is made of?
During the investigation, because, we want to make sure that whoever's complaining, whether it's the charity, because we do have charities that do call and complain about, fraudulent activity that's happening in other spaces or with other supposed charities, we will look into everything. Mhm.
Has what number of investigations has resulted in action of, I don't know if it's action of suit or action of to take action on?
To take action. A lot of the cases that involve that we get complaints have to do with unregistered activity, that, oh, they're out here and they're not registered. Why not? So many of those cases resolve because, as I said, the legit charities want to follow and follow the rules because it makes their donors comfortable. So usually when we do an unregistered reach out, we will send a letter out asking, we found out you're in our state soliciting, can you claim an exemption? Which one is it? And sometimes they will claim the exemption, which we're fine with. It's up to them, to tell us which one. Other times, they will say, oops, my bad, I meant to register. So we will help them with that process to get them registered. Now, the real fraud charities, the most recent one was the one that I just told you about, the Georgia Peach. That's the biggest one.
I appreciate your testimony. There being no further questions from the committee, I'm going to clarify which bill is subjected for consideration from the full committee at the discretion of the chairwoman, which is LC 471798S is the author and agreement of that.
That's right. Thank you.
Thank you. Thank you for
Thank you,
coming.
Mr.
today.
Chairman.
Thank you.
Thank you.
All right. Let me find the agenda. We will go to SB 227. Is the representative or senator here for the bill? Thank you, Senator. Senator Harold?
Yes.
How are you?
Good. How are you?
Good. If you would go ahead and read out your LC number. To make sure we have the same one.
LC 490930S.
490930S. Yes, sir. All right, go ahead and.
Thank you, Mr. Chair. This bill deals with eminent domain, and there's a lot of parts of it that are underlined, but in reality, it's not as complicated as it may seem. So this deals with, as we know, with eminent domain in Georgia under 2211, public use exists where there is blight, and economic development is just a secondary factor. We define blighted property under this particular section, where at least two things must exist, and also a third, which is it has to be dilapidated, unsafe, or uninhabitable. It has to be inadequate provision for ventilation or repeated illegal activity. Those are normally the three things that you would normally find with blighted property. But it also then has to provide that it is ill conducive to health, transmission of disease, infant mortality, or crime. So you have to have one of those, two of those first factors, and then it also has to create ill health, infant mortality, crime, one of those. Blight impacts the overall community and a well-balanced community. And that's what we basically decided when we passed 22-115, that blight was not necessarily there for just economic factors, but it was one that affected the overall health of the community. So the question becomes, though, what happens when a property does not meet the metric of blight, but the impact is the same? So the metric of blight of being basically one that is dilapidated, basically one that's going to cause is ill health, basically one that is crime ridden, that metric may not be met, but at the same time, the impact, the overall health of the community, the well balance of the community is still impacted the same way. And what we're finding in Georgia and elsewhere is that these types of properties exist in what we commonly term dead malls, is what the common term of it is. And so whether you have these particular facilities that because of their size, they really cannot even afford to go into a dilapidated condition or have crime ridden. And to some extent, the counties themselves make sure that doesn't happen. So in that sense, they're not going to fit the metric of blight. Now, if they do, then of course 22-115 could be used. But they're there and they still have the impact of blight, that well-balanced community. They still have that negative impact that exists. And this is a problem that is occurring in Georgia, whether it's in Augusta, where I'm from. Gwinnett County recently dealt with this. They paid $23 million for their particular dead mall. Macon is dealing with that. Savannah is dealing with it with one of their particular malls. And it's one that's going to continue when we understand that I think Moody's Analytics says that 25% of all malls will probably close within the next 2 or 3 years. So this is a problem, and retail, of course, is also following just because of the new economy that exists. So this is a problem that exists today in Georgia and will continue to actually flourish, unfortunately, more so just because of the nature of the economy is changing, but it is a problem that will exist. So this tries to deal with that. And what it tries to do is say, look, if you're a structure that is at least 375,000 square feet, we get that from the standpoint that most of your malls or shopping centers average 400,000 square feet to 800,000 square feet. So that's where that actually comes from. The mall in Augusta that kind of spurred me to even look at this issue is actually over 800,000 square feet. So, but most malls start from 375 to 800. If it's been legally vacant for 10 consecutive years or less than 30% occupied for 20 consecutive years, at that point in time, then that particular structure could be declared to be blighted. And I think that we also should make note that all of the provisions in this Title 22 remain the same. The notice and hearing provisions remain the same. The owner is still going to get notification. They're still going to have a hearing. A petition still has to be filed with the Superior Court in Georgia. All of those provisions will remain the same. The fact that just compensation must always be paid on any eminent domain action still remains the same. The only thing that's really being changed here is a recognition that blight may not always meet the initial metrics that we think that is met, but the effect on the community though is the same. And we've narrowed it down to these just particular commercial structures. And I'll make note that it is commercial structures. So we certainly have narrowed that down to commercial structures at 375,000 square feet. And we also placed the limitations in there, how long they needed to be vacant. This is just another tool that a county can possibly use. There are other tools that counties have, whether you're looking at Title 36, whether you're looking at Title 22-115, there's other tools there that they have. This just provides another one. It doesn't mean that counties are now all of a sudden going to start trying to use eminent domain. It just gives them another opportunity. As one commentator said, the problem with trying to revive dead malls is trying to revive dead malls. It's not an easy thing to go into. This is nothing that counties are just going to rush and try to do. It's a complicated situation when you're trying to do it because of the nature of the economy. So therefore, it's just another tool that does exist, but some of these counties could have used that over the years. Many of these counties have done that. So that's one of the things we also wanted to do was place a time restriction, also place a conveyance restriction on here. If this property had been conveyed, so if you go to court and you have a hearing, and even though the property had been declared to be blighted under this particular code section, on this section 22-116, if that property had actually been conveyed within 2 years, then the clock actually starts over. So we're actually trying to protect persons who may actually buy one of these properties. Of course, it would be at a large sum, who may buy one of these properties and say, well, I have not had that for that 10-year period of time. I wasn't given that opportunity to try to change anything. If that happens, the court will say, look, this could have been a blighted property, but this conveyance stops us from making that ruling. And you get one opportunity to do that. And that is not necessarily even a forced sale. The original owner can still be an owner of the property. It's just that that person would lose 50% ownership, and it doesn't have to even be during a sale of the property. So I think it protects property interests, but at the same time, it deals with the reality of how these particular structures are impacting communities. And with that, Mr. Chair, I'll take any questions.
You have 2 questions. I'm going to start with 3 now. We'll go with Representative Williamson first. You had your chair. Is it 20? Are you 27? The chair lady.
Thank you, Mr. Chair. Just a couple questions. I know this is referring to commercial buildings,
Yes, ma'am.
and it uses urbanization or urbanized. I'm in a rural community. It's not very urban, but we may have a building that is in that same condition. Would it be covered under this legislation?
That
And-
language actually comes from 22-115, and it also still is not adequately defined, but basically it means that you're talking about a situation where if you look at urbanization within just the normal definition, it means basically that the property has been developed.
Okay.
That's where I was able to get it from. So you see the same definition, I believe, is in 22-115 or 22-111, which it talks about urbanization. And I had the same question about that, but in reality, it really just means developed property is what it means. And also, it also could mean commercial property. And I think that's key, but that is a very good question there. But I don't necessarily know if it means like a cityscape that we may be thinking, because when you kind of look at the definition, it talks about space, landscape, but also a group of buildings or a nature of buildings when we talk about urbanization.
We have buildings like every community, and there used to be a warehouse. They used to be a number of different things, and they are close to our downtown. And they may have fallen to disrepair or not being kept up, and they're just, I'll say being maintained, but just barely. Would this mean the county can come in and just take the property, or will they purchase it? How are these transactions going to be done?
Right. So actually, what you actually described is interesting, because in reality, I would think that your county actually could maybe possibly use 22-115 if they're in true disrepair and you're having some of those issues. But it would work as any other condemnation process would work. So the county would say that they're trying to condemn the property based on it being blighted property, and they would just go through the same hearing process. It's once again, and this is, I think, where terms really do matter. It's not necessarily a taking, because it is just compensation is guaranteed in our law. I think that's 2215. It is guaranteed. Not only does the owner have the opportunity for just compensation, if there's not an agreement there, it would then go to a court. Also, the owner, and a lot of times we think about this from housing, but it would apply the same way here. The owner actually has to gets the opportunity to have their own appraiser come in and actually be with the government as they appraise the property. That would come into court. That the reason for that is if it went to court because they have a disagreement on just compensation, the owner's own appraisal would have been there at the time the appraisal took place. And so therefore they could actually testify and say, these are the issues I have with this particular appraisal because I was there and I know what they were looking at. And this is the issues that I have. So when we start talking about condemnation, at least in Georgia, it is I want to say a lengthy process because we want to make sure it's actually quick, but is it an involved process? It's not one that the county can just jump into. They have to do a statement also within their petition why they're declaring this to be blighted property. Actually, even before you get to that point, we encourage the mandate that they actually do negotiations with the property owner first before they can even do the petition. That's like step one. So a lot of times when we talk about condemnation, and we all use these terms when we say taking and things of that nature, at least in this state, we've developed a mechanism that requires counties to really go through a process before they can even institute condemnation proceedings. We developed a process that's going to make sure a person is going to get just compensation. And even if that cannot be agreed upon, there's a process there for a court to intervene in that. So we have I think, a good system to protect property owners. And in this situation, many times you're talking about, in this situation here, you're going to be talking about large corporations. What really is happening now is a lot of your corporations, they will just sell to each other for whatever purposes. They'll say, we'll make it better. We'll make them all better. And then they'll sell later, say, we'll make them all better. But these are going to be large corporations that the counties are going after. And so it's going to have to something that they're going to have to seriously consider. Because if you lose, if for whatever reason, you're also on the hook for attorney's fees and court costs, and those fees would be kind of high too.
Okay, one of the things I know we've done is our Economic Development Authority worked with the owners of the property and were able to renovate it and do it that way. It did not have to go to this. So it's a big step for someone to take where there were other remedies besides just going so seriously, I guess, about it. But thank you. I appreciate
Yes,
that. Thank you.
absolutely.
We have one more question, Representative Williamson.
Thank you. First of all, is this hearing only, Mr. Chairman?
All bills heard within subcommittee are hearing only. It's not indicative of good or bad on the bill.
Okay, well, thank you. That I don't want to belabor any points here, but thank you, Senator, for explaining your intentions of this bill. I guess I've got several questions. You referenced several local governments that had acquired malls. Were any of those done through the condemnation process?
The only one that I know actually required one was the Gwinnett. That was recently. That was not done through the condemnation process. That was just a straight sale, from my understanding.
So
The others that I mentioned are just others that have abandoned malls that have these issues, even though one is actually kind of trying to develop into like an office space or something of that nature. Yeah, but the only one I know about the sale was Gwinnett, and that was $23 million.
And I guess my point is that, you, in your testimony, you acknowledge the fact that our current condemnation and blighted properties law seems to be working pretty well for both the property owners' benefit as well as the local governments when they need to step in when it is in fact a blighted mall. But it appears to me your bill, as you testify, is taking buildings that are actually not blighted under our well-working code right now, and we're going to use the descriptor that they are blighted because we feel like we can do something better with it than the private markets can. And I guess I should throw in that. And don't you see a problem with that?
Right. So the way I kind of look at that is, if you remember, and of course, this is a case that a lot of people have criticized, but in the Kelo case, one of the things the court said was that economic development has never just been about taxes. It's about the impact on the community. That's kind of where I look at this blighted mall situation. It actually now is forward thinking. Blight is not about necessarily the aesthetics or just the crime or something of that nature. Blight is the impact that it has on the community. And so if these malls are having that negative impact, causing a community not to be well balanced, not to be community centered, that's why I was saying the metric of what we say is blight may not be there, but that's just our definitional term. We could have always used that other definitional terms. But the impact, and that's really what we were trying to get at, was the impact that these properties have. If the properties had no impact, we may not have necessarily cared about them to change our definitional to blight property. It's really the impact that we're getting at. And so it's actually saying, don't narrow our view of what blight is, because if we narrow our view of what blight is, we're going to miss that these properties still have the same impact.
Well, again, I appreciate you explaining your position on the bill, but the example you use of something could be from another opinion at blight. You could have the little retired school teacher with a beautiful little well-kept home in the middle of an urban area and refuse to sell, and it keeps what the city father's eyes might believe is going to be this fabulous new office development, but they can't do it absent this 1 acre parcel in downtown Atlanta or downtown Columbus.
Right.
But that would be, in your own words, an example of something for the greater good. You're willing to take this well-kept little retired school teacher's home because it would create jobs and money would flow through the economy.
Well,
You're selling it. You're buying it over the objection of a property owner that's not that the property's not meeting the definition of blight. But so I understand your perspective. I hope you understand mine.
Address that. We have one more question for you.
sure. I would just say that at the end of the day, of course, it's always up to the legislature how we do that. So when we talk about slippery slopes, this bill says 375,000 square feet in commercial property and the rationale behind that. So for us to then use that rationale to the elderly woman with one house who is not impacting negatively the community, because there's a difference. We're not saying that this mall, we can do something necessarily better to impact positively. We're saying it's actually having a negative impact today on the community, where the elderly lady's home is not having a negative impact on the surrounding community. We just
I
want to
understand
take
your
it
perspective,
away.
but thank you for explaining.
Thank you. Let's go ahead and go to Representative Maynor online.
Thank you, Chair. My question is, I have Morris Brown University in my district, and they have a stadium that has not been used, and the size would meet the requirements that you're saying. It's a private institution. So would this fall under the guidelines of the legislation you're presenting?
If it was basically what we're talking about from the standpoint of being a commercial entity, and we'd have to look in the code section to make that determination if a stadium is necessarily a stadium, it would necessarily be declared to be a commercial entity. But that is certainly something to look at. But of course, that's not the intent that we're looking at here necessarily. And I don't know if it would actually even fit the structural requirements either. But we'd have to look into that as far as an empty stadium being a commercial entity, number one, and then also the structural requirements, number two.
Okay, thank you.
Yes.
Thank you for presenting the bill as indicated prior. We have sorry, Jason, didn't mean to forget about you. We have wherever you prefer. The emergency, the EMCs would like to weigh in.
Thank you, Mr. Chairman. Mic on? Okay, good. And first off, Jason Bragg from Georgia EMC, Vice President of Government Relations, represent the state's 41 electric membership cooperatives along with Georgia Transmission, who is our high voltage transmission company that sells that gets the wholesale power to your EMC from our generation facilities. I want to thank Senator Jones and Whip Jones for meeting with us this morning. We had one small little, not concerned with the overall bill, but just the impact that it may have on the rest of the condemnation statute that is currently in 21.1. We had basically What we're looking to do is essentially say that the definitions that are used in Senator Jones's bill 227 and the new code section is created, the definitions only apply to that code section. And so there's no confusion when the courts look at this and any other condemnation things that may be down the line. We had an amendment that I know I've shown to you, and I got a chance to talk to a couple members of the committee to say that it's basically one line, and it would go on between lines 99 and 100 in the bill. And essentially just says all definitions of terms in OCGA 21-116 shall only be applicable to this code section, OCGA 22-116, and shall not serve to alter or amend any definitions contained in OCGA 22-11-1. So that's all it is. It's just a belt and suspenders thing to make sure that none of this affects anything that is in our existing law, because those of you that may have been down here a while, it was before my time in 2006, know that when we had to rewrite this entire statute, it was quite the process, and we want to make sure to keep it that way and make sure all the public notification and thing is in there that we have to do currently, if we have to condemn property. That's it.
Thank you. I don't think you have any questions. I appreciate the clarifying language and the author's ability for that to be heard. We will not do because all bills are hearing only, we'll just go forward with the understanding that if it's heard in full committee, it'll be heard through a substitute with that information present. I want to close on this bill with this. I appreciate Senator Jones, the intent of acting on your community and possible some other Georgia communities problems. I think Jacksonville, Florida happens to be south of my district, and they have that same similar issues with that area. I also share Representative Bruce's concern on any bill that addresses the utilization of private property for public purposes. I think we should look at that very thoroughly and delinquently, not to say that this may be a case where it is justified. So with that, the bill has been heard in subcommittee adjacent to the rules of this committee. And we will move on to thank you for coming. And we will move on to SB 337. Is Senator Walker here? Thank you.
Thank you, Mr. Chairman. Thank you, committee. So I'm bringing you Senate Bill 337, but I want to give you a little background on this. Last year, we passed a proposed constitutional amendment, Senate Resolution 134.
Let me clarify the LC for you. And do you need a copy?
I have it on my phone, so I can read it.
You're a better reader than us, so all right, then I would be.
LC 280365.
Thank you. That's what we have.
Senate Bill 337. So Senate Resolution 134 is a proposed constitutional amendment on a statewide elected officials, including legislators too. If we're removed from office due to a felony indictment, and there's a process already in the code to kind of a due process already in the current code to remove them from office. But if they're removed from office due to this felony indictment, we would, and the constitutional amendment passes, it'll be on the ballot in November, then their pay would be suspended until the adjudication of the trial. If they're exonerated, then they would get, their pay would be reinstated. And that bill actually passed the House unanimously. So this is the same concept, except dealing with local elected officials. So dealing with your city councilmen, mayors, district attorneys, it lists them all out. I can read them to you if you'd like. But if they're removed due to a felony indictment, and we all realize that you're innocent until proven guilty, but the nature of the felony indictment has to be such that this committee is, if they go through the process and a commission's established and they determine that the felony indictment is of such a nature that they're unable to perform their official duties and they have to remove them from office, then the local government would be able to suspend their pay, because they're going to have to appoint an interim person in the meantime to actually do the job, and they're going to have to pay them. So it keeps the local government from having to pay them twice and saves the taxpayer the possibility of, what basically wasting that money. So it's pretty straightforward. That's what it does.
So just to clarify, the only instance where there would be duplicate pay would be if the indictment wasn't validated by the trial or at the end. But this would prevent that duplication from happening if it was held. Is that fair?
Yes, sir, that's correct. So if they're found not guilty, then the back pay would have to be paid and they'd be reinstated to their position.
We have one question, Representative Williamson.
Thank you, Senator, for bringing this. I like the bill a lot. Clarify for me, the legislation we previously passed included all members of the General Assembly, or did it not?
It did, yes, sir.
In reading the local elected officials that you touched base on here, does it address the judiciary as well?
It does not. And the reason it does not is we have a JQC that Judicial Qualifying Commission that oversees the judges and is in charge of removing judges and has authority over this kind of thing with judges. And that's why it's not in there. If you would like, but that's why now, if we legally could put it in there, I don't have any objection to put it in there, but
you're just educating me. Thank you for explaining that. So,
and we don't have a prosecuting attorneys oversight commission like JQC. And so district attorneys are included in this legislation.
Does it come with any objection from any of the affected positions, any of their associations?
The prosecuting attorneys counselors, I guess is what they're called. They don't particularly like it, but they didn't voice that in committee. They just told me in the hall.
Has Association of County Commissioners or Municipal Association made a comment on it?
They have not commented one way or the other, to my knowledge. They don't oppose it as far as I know. I think they would, it seems like they would naturally favor it to me, but.
All right, thank you. We're going to go ahead with the two continue. Madam Chair, are you 26? 27, and then Representative Gullett.
Hi, just a quick, constitutional officers, or do they have their own rules? That would be like an insurance commissioner or someone, are they, I
So
didn't see.
that's the proposed constitutional amendment that your body passed unanimously last year, and it'll be on the ballot in November of this year.
And we did not include these other folks, the county folks. That's why it's two separate bills, I guess. We already did one.
Yes, ma'am. The local officials are not required to be in a constitutional amendment. The Constitution doesn't speak to it for local officials. So
Okay.
that's why we ran it as two separate bills. This just requires a 50% plus one vote of each body. And if the governor signs it, it goes into law.
Thank you. It's a good bill. I
Thank
appreciate
you.
it.
All right, Representative Gullett.
Senator, appreciate you bringing this bill. I know it kind of goes hand in hand with some things I'm working on, especially related to the district attorney. As you know, in my county, my district attorney was suspended and received pay for almost 2 years before he actually finally pled guilty. But we did pay an acting district attorney that time. So we were duplicative. I guess the state as well. The state pays the district attorney as well as the county as a subsidy for them. So it was a lot of wasted money for these. So thank you for bringing this bill. And I do hope that we do change that prosecutor oversight commission and get that thing through this year. And I appreciate your help as you and I've talked about that bill and look forward to have that opportunity too. But this is a good bill and I appreciate it.
There's always hope in there.
That's right.
Until Sonny die, we're working on it.
Yes, sir. I know you guys are. Thank you.
All right, Representative Maynor on Zoom.
Yes, thank you, Chair. My question is almost a follow-up to Representative Gullett, because he does have HB 411 in the Senate Judiciary for the Prosecuting Attorney Oversight Commission. With that in mind, you mentioned that you did not put the judges in here because they have the JQC. And so, how does that play? How do you see that playing out if Representative Gullett's bill passes with the language that you have right now?
I can't really speak to Representative Gullett's bill I know I'm for his bill, but I'm not on judiciary and I really don't know what the posture of the bill is.
Thank you, Senator. It's always nice to have a senator clarify that they don't have the answer to something and look to a representative for it. So we'll recognize Representative Gullett.
In his defense, I told him I would take it. Representative, I think that it should still stay in there. At the end of the day, if the person has been convicted of a felony, or the district attorney or even solicitor has been, this prosecutor oversight commission affects the elected district attorney and the elected solicitor of the county, or the judicial circuit. So I would think that you'd want to keep those in there, because that just takes away one thing that the prosecutor oversight commission wouldn't have to do. And I get why the judges aren't there. I don't think it's a bad thing to add them to this, but JQC does a pretty good job today, I think, of that, whereas there's no mechanism for this in these other positions that are no mechanism for removing their pay in these other positions that are listed. So whereas there is a mechanism with the JQC for the judges, and just in case that prosecutor oversight commission doesn't get passed, this would at least allow some other communities not to have to pay if the person is guilty or suspended and ultimately not if found guilty. Hope that answers it.
Thank you. Is there any further comments from the author?
No, I appreciate you.
All right. Well, we appreciate you coming to our committee. Based on the rules of this committee, it's available for consideration from the full committee based on the will of the chair lady. And with that, we are breaking still within an hour at 2:59. Thank you all for coming.
Thank you.